Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, listener learners. I welcome all respected deputy directors. I welcome honorable ministers and managers. I welcome all honorable advocates and advisors and district advisors. I welcome the most honorable presenters Modi ji, Dr. Rakesh from USA, heartily welcome. It is very nice time, nice place, nice action today that we are defining our Polynesian cultural identities in the form of unity diversity. भारत से रूस के लिए रवाना हुए पुतिन भारत से रूस के लिए रवाना हुए पुतिन international law is really low. Most of the jurists now subscribe to the view that international law is really low so far as the sanction or pursuit force behind the law concerned. It may be said that it is not an essential element of law, and even if sanction is regarded as an essential element of law, there are sanctions in international law. The common law of England is its glaring example. To some extent, Covenant of the League of Nations provided, and now the UN Charter provides for some sanctions so far as the legislative, judicial, or executive branches in the international system are concerned. What matters is not whether the international system has legislative, judicial, or executive branches corresponding to those we have become accustomed to see in a domestic society. What matters is whether international law is reflected in the policies of nations and in relations between nations. Further, the fact is, lawyers insist that nations have accepted important limitations of their sovereignty, that they have observed those norms and undertaking, that substantially the result has been substantial order in international relations. Dagestan, who has also criticized the Augustinian concept of law, subscribes to the view that international law is really law. In this connection, he has put forward four main arguments. In the first place, it has been established by modern historical jurisprudence that in many communities a system of law existed and was being observed through such communities lacked a formal legislative authority. Such law did not differ in its communities, binding operation from the law of any state without true legislative authority. Secondly, Austin's views might have been correct for his time, but in view of present day international law, use might have been correct for his time, but in view of present day international law, they are not true. Customary rules of international law are diminishing and they are being replaced by lawmaking treaties and conventions. Lawmaking treaties are counterparts in the international system of the legislation in the municipal legal system. Thus, international legislation has come into existence and it is now wrong to say that international system has no legislation at all. Hardly the authoritative agencies responsible for the maintenance of international intercourse do not consider international law as merely a moral code. Lastly, the United Nations is based on the true legality of international law. Oppenheim regards international law as law because of the following two reasons. In the first place, international law is constantly recognized as law in practice. The government of different states feel that they are legally as well as morally bound to follow international law. Secondly, while breaking international law, states never deny its legal existence. On the contrary, they recognize its existence and try to interpret international law as justifying their conduct. An emerging system of sanctions for the enforcement of international law, recourse to law-making treaties, and certain aspects of the activities of international organizations, indicating the emergence of legislative process, recognition of certain rules having the character of just province, etc. are some of the indications of a growing maturity in the international legal order. Indeed, international law may now properly be regarded as a complete system, further while the frequency of the violation of international law may strain its legal force to breaking point. The formal, though often cynical, affirmation of its binding nature is not without significance. Frequent violations do not prove that the law does not exist. Even municipal or state law is frequently violated. But as pointed out by Oppenheim, violations of international law are certainly frequent, especially during war. But the offenders always try to prove that their acts do not constitute a violation and that they have a right to act as they do according to the law, or at least that no rule of the law of nation is against their acts. It is true that frequency of violation of international law may strain its legal force to breaking point. For example, during the Second World War, rules of international law were frequently and flagrantly violated. For some time at least, it appeared as if no law existed, but thanks to the inner vitality of the law of nations, within a few years, faith in the law was again revived, and states again reaffirmed their faith in the rule of law. They demonstrated this by establishing the United Nations, which is based upon the true legality of international law. Even when states violate rules of international law, they do not deny the existence of law but try to justify their conduct and affirm the binding future nature of the rules of international law. The affirmation is significant for it tends to the strength of the law and the legal system. As pointed out by Edward Collins, international law is created and is deemed to be legally binding by authoritative nations, national and international decision makers because they understand that generally agreed upon rules and principles of action serve the indispensable function of providing a basis for the orderly management of international relations. Briefly has also aptly remarked, it is both practically inconvenient and also contrary to the best heuristic thought to deny its international law legal character. Professor H.L.A. Hart has also written, it is clear that in the practice of states, certain rules are regularly respected even at the cost of certain sacrifices. Claims are formulated by reference to them. Breaches of the rules expose the offender to serious criticism and are held to justify claims for compensation and deletion. These surely are all elements required to support the element that there exist among states rules imposing obligation upon them. The arguments of the jurists who regard international law as really law may be summed up. The term law cannot be limited to rules of conduct enacted by a sovereign authority. Sir Henry Mann, one of chief exponents of historical school of jurisprudence, carried out research on historical jurisprudence and firmly established that in primitive society there was no sovereign political authority, yet there were laws. The Augustinian concept of law fails to account for the customary rules of international law. So we accept the Augustinian definition of law, common law of England will lose its legal validity. Customary rules of international law are diminishing and are being replaced by law-making treaties and conventions. Today, the bulk of international law comprises of rules laid down by various lawmaking treaties such as Geneva and Hague Conventions. The rules laid down by these treaties are binding although they do not emanate from a sovereign political authority. When international questions arise, states do not rely upon more arguments but rely upon treaties, precedents, and opinions of specialists. States do not deny the existence of international law. On the contrary, they interpret international law so to justify their conduct. In some states, for example, USA and UK, international law is treated as part of their own law. The leading case on the point is the Packwood versus Habana, wherein Justice Gray observed international law is a part of our law and must be ascertained and administered by courts of justice of appropriate jurisdiction, as often as question of right depending upon it are duly presented for their determination. As per statute of the International Court of Justice, the International Court of Justice has to decide disputes as are submitted to it in accordance with international law. International conferences and conventions also treat international law as law in its true sense. The United Nations is based on the true legality of international law. So far as sanction in law is concerned, international law does not completely lack it. It is true that international law is frequently violated, but it does not mean that international law is not law. Even state or municipal law is violated. Frequent violations of law indicate the weakness of enforcement machinery and have nothing to do with the legality of the rules. Legality of rules and enforcement of rules of law are two different things. The decisions of International Court of Justice are binding upon the parties to a dispute and only in respect of that dispute. The powers and jurisdiction of International Court of Justice are not equivalent to the municipal court, but under certain conditions, its decision can be enforced. Article 94 of the UN Charter provides that each member of the UN undertakes to comply with the decision of the International Court of Justice. It further provides that if any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court, the other party may have recourse to the Security Council, which may, if it seems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment. On the basis of above arguments, it may be concluded that international law is really law. However, it has to be admitted that international law is not equivalent to municipal law. It is obvious that international law, unlike municipal law, operates in a decentralized political system. There is no world legislature, no international policies, and no international court with compulsory jurisdiction. Stark has expressed the view that international law is a weak law. He writes, the cumulative evidence against the position taken by Austin and his followers should not blind us to the fact that necessarily international law is weak law. Existing international legislative machinery operating mainly through lawmaking conventions is not comparable in efficiency to state legislative machinery. But despite the weaknesses of the international legal system, the legal character of international law cannot be denied. Moreover, this weaknesses becomes manifest when we compare international law with municipal law. But this comparison is not happy and appropriate. International law operates in a decentralized system, whereas municipal law operates in a centralized system. International law must be judged in the context of system in which it operates. As aptly remarked by Judge Philip L. Jessup, important to restate a great nation which has no decent respect for the opinion of mankind, falling in its severest test of serving as a substitute for here. International law plods on its way, followed automatically in routine affairs, invoked, flouted, codified, flouted again, but yet again invoked. But can one say that the international law with which they deal has no reality? Indeed, no one can deny the legal character of international law. As compared to municipal law, it is definitely weak. Nevertheless, it is law as a matter of fact, as pointed out by J. Brierley. International law is neither a myth on the one hand nor the panacea on the other, but just one institution among others which we can use for the building of a better international order, as aptly remarked by Professor Louis Hankin. Fortunately, international law exists and it works, not perfectly or always, but well enough and often enough to make a considerable difference in the conduct of international law affairs. Although there is no one to determine and adjust the law, there is wide agreement on the content and meaning of law and agreements. Even in a divided world, buzzing with new nation. Moreover, as I pointed out, as pointed out in the ninth edition of Copenhagen International Law. Furthermore, international law may now properly be regarded as a complete system. By this is meant not that there is always a clear and specific legal rule regarding readily applicable to every international situation, but that every international situation is capable of being determined as a matter of law, either by the application of specific legal rules where they already exist or by the application of legal rules derived by the use of non-legal techniques from other legal rules or principles. Last but not the least, most of the controversy about the legal character of international law is due to the tendency of the jurist to compare it with municipal law. As indicated above, the comparison is not happy. Unlike municipal law, international law operates in a purely decentralized system. Due to this peculiar reason, international law is bound to be distinct from municipal law. International law must be understood and appreciated in the peculiar system in which it operates. It is good. It is as good and effective as it can be under the circumstances and peculiar system under which it operates. International law and municipal law. It has been pointed out, although international law is readily distinguishable in many respects from domestic law, it is nevertheless a system of law possessing certain characteristics peculiar to itself as well as certain others common to municipal law. It cannot be denied that the international legislative machinery operating mainly through lawmaking convention is weak as compared to the legislative machinery of states because states enter into treaties and conventions on the basis of equality. Sovereign equality of states is a well recognized and established principle. There is no power over and above the states. The international executive and judiciary are also weaker than their counterparts in the state system. There are, however, certain similarities between the two, like state judiciary in the international legal system. Also, there is a court, International Court of Justice, and under Article 59 of Statute of the Court, its decisions are binding upon the parties to a dispute, and in respect of that dispute, more than 47 states have conferred compulsory jurisdiction upon the court. Similarly, Security Council may be said to be the executive of the international legal system under Article 94 of the Charter of the UN. If a party to the dispute before the International Court of Justice fails to implement the decision of the court, the other party may bring the matter before the Security Council, and the Council may make recommendations or decide the measures to be taken to implement the decision. However, it may be noted that apart from this, Security Council's main function is to maintain or restore international peace and security. Unlike state law, it does not possess powers to enforce law. For example, international law as such, and this is probably the greatest weakness of international law. Thus, international law possesses characteristics peculiar to itself as well as certain others common to municipal law. In the words of Palmer and Perkins, international law is largely but not altogether concerned with relations between states, whereas municipal law controls relations between individuals and the agreement with, however, substantial differences in legislative machinery, they differ altogether. In their judicial processes, both are applied by national courts, which results in complete decentralization of the judicial function in international law and effective centralization in municipal law. What is true of the judicial function is also true of the executive function, as in tort in domestic law. Traditional international law always depended for its enforcement upon the initiative of the injured party. Most municipal laws, on the other hand, are enforced by a responsible executive unknown to international law. Theory and reality in international law. In the international legal system, there is a great difference between theory and reality. That is why Immanuel Kant has criticized international law by remarking the pompous law of nations, which is so eloquent in books and silent in the cabinets of diplomats. There are those who assert that international law, in order to be worth its salt, must be based solely upon logic and principle. But international law, withstanding the reasoned thesis of the commentators, consists in the last analysis of those principles upon which sovereign nations can agree. Such agreement is seldom, if ever, reached without regard to the political process. Usually, the international law aspects of international relations are so commingled with political, strategic, economic, geographical, social, and other elements, and in consequence, it may be difficult to determine the exact part played by international law. Account must be taken of these non-legal factors in analyzing international incidents which have taken place or in predicting do what states will do in a given situation. One of the main reasons for the difference between theory and reality in international law is the concept of sovereignty, which each state is sovereign and equal in the eye of law. There is no power over and above the state. Whenever the national interest of a state are affected, it resorts to the concept of sovereignty and hence its decision or action is based more on its own interest than on the rules of international law, and it claims that even international law allows it to exercise its own discretion in such matter. For example, international law recognizes the essentials of statehood of a state. It also recognizes that certain legal consequences ensue when a state is recognized, but it depends upon the sweet will or discretion of a state whether to recognize or withhold recognition of a politically organized community which has emerged as a state. It is the recognizing state itself which decides so far as the relations between the recognizing and the recognized states are concerned as to whether a politically organized community has in fact attained statehood, and this appraisal cannot be questioned. And obviously, in many cases, decisions of the recognizing state are motivated by political consideration. At present, it is generally recognized that the sovereignty of a state is neither indivisible nor unlimited. States have now agreed to the curtailment of part of their sovereignty in the interest of international community. This is true, but in practice, whenever the interest of a state is adversely affected, it invokes the concept of sovereignty. Thus, sovereign equality is one of the keystones of international legal system. Even the United Nations Charter provides that organization is based on the principle of sovereign equality of all its members. Yet another example of the difference in theory and reality is in international law is the rules developed in connection with the relationship of international law and municipal law. In principle, most of the states recognizes that customary rules of international law are part of their own domestic law, but they have made these principles subject to so many exceptions that in practice whenever there is any conflict between a rule of international law and a rule of domestic law, it is the latter which prevails over the former. Relationship of law and power in international relations cannot be ignored, and hence international law, a normative order, should conform to the twin test of meeting social needs and reflect true state of international practice among states. Distinction between public international law and private international law. At present, it is generally recognized that the sovereignty of a state is neither individual nor unlimited. States have now agreed to the curtailment of part of their sovereignty in the interest of international community. This is true, but in practice, whenever the interest of a state is adversely affected, it involves the concept of sovereignty. Thus, sovereign equality is one of the keystone of international legal system. Even the United Nations Charter provides that organization is based on the principle of sovereign equality of all its members. Yet another example of the difference in theory and reality is international law is the rules developed in connection with the relationship of international law and municipal law. According to Pitt-Cobbett, distinction between public international law and private international law. The definition of public international law, or commonly known as international law, has been discussed in detail earlier. At one time, international law was defined as the body of rules which regulate relations among the states. One of the main distinctions then one of the main distinctions then between public and private international law was therefore said to be that while the former regulated relations among states, the latter regulated the relations of individuals. But in view of the expansion of the subject of international law, old definition of public international law has become obsolete and inadequate. Public international law now regulates the relations among the members of international community, which include individuals also according to Pitt Corbett. Private international law is the body of rules for determining questions as to selection of appropriate law in civil cases which present themselves for decision before the courts of one state or country, but which involve a foreign element, for example, which affect foreign persons or foreign things or transactions that had been entered into wholly or partly in a foreign country, or with reference to some foreign systems of law. Thus, private international law is that branch of international law which decides law applicable in the issue in disputes involving more than one nation and determines the court which will have jurisprudence to decide the issue. It is more popularly termed as conflict of laws. Main points of difference between the public and private international law are public international law, for its major part, deals with states and to a lesser extent deals with the individuals. Private international law deals with the individuals. Private international law is a part of municipal law, but so is not always the case with public international law. Only customary rules of international law are considered to be part of the domestic law of states. Public international law, at least rules having general application, is same for all the states, whereas private international law may be different in different states. Private international law determines as to which law will apply in a case having a foreign element. There is no such problem. In the field of public international law, public international law is confronted with different type of problems whenever there is conflict between it and the internal law of a state. The problem arises as to which will prevail. Private international law also determines the court which will have jurisdiction to decide the issue in question. In this respect also it differs from public international law. According to Robert Fillmore, rights arising out of public international law are absolute and their breach constitutes a causes bell, for example, whatever involves or justifies war. This view does not seem to be correct in the presence of the provisions of Klein Brand. Pact and the UN Charter, which have outlawed war, but private international law does not at all confer absolute rights. International law comprises mainly of the rules recognized by states in their relation with each other and mostly arises out of international customs and treaties. On the other hand, rules of private international law are framed by the legislature of a state and recognized and developed by state courts. In some exceptional cases, rules of private international law may become rules of public international law when they are incorporated in the international treaties. In such a case, if a state party fails to observe the rules of private international law, proceedings may be started against it for breach of an international obligation or to other party. Even in those cases where rules of private international law cannot themselves be internal law may directly involve the rights and obligations of the state under public international law. For example, matter concerning the property of aliens or the access or the extent of the jurisdiction of a state, according to Palmer and Perkins, as distinguished from public international law. Private international law is a branch of law which deals entirely with the relations of persons living under different legal systems. Occasions for the application of private international law arise when justice requires that law of some outside jurisdiction, not necessarily a foreign state, be applied in a particular case. For example, to cite a famous English situation when couples left England to be married in Scotland, where the marriage laws were less stringent, and question arose whether the validity of the marriage should be determined by English law or by Scottish law. The English courts held that the laws of Scotland should apply. Frequently, the nationality of a person is the issue. International law, a mere positive morality. आतंकवाद के खिलाफ वैश्विक एकता बड़ी ताकत रूस तेल गैस भारत को बिना रोक टोक तेल देते रहेंगे पुतिन से ऊर्जा क्षेत्र में भी सहयोग जारी रहेगा आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से भारत रूस सम्मेलन पुराने रिश्ते नई उड़ान शिपिंग ट्रांसपोर्ट को श्रम और दूरसंचार क्षेत्र में दोनों देशों में समझौते मेडिकल एजुकेशन पर भारत रूस में समझौता कामगारों की आवाजाही पर दोनों देशों में समझौता मेडिकल एजुकेशन सेक्टर में भी समझौता मोदी पुतिन की दोस्ती विशेष दुश्मनों को संदेश अस्थायी लेबर एक्टिविटी पर भी समझौता भारत रूस मित्रता ध्रुव तारे की तरह है चुनौतियों के बीच मित्रता ध्रुव तारे की तरह है भारत दौरे पर पुतिन दोस्ती का नया अध्याय 23वां भारत रूस सम्मेलन श्रम और दूरसंचार क्षेत्र में दोनों देशों में समझौते मिलकर यूरिया उत्पादन के प्रयास भारत रूस नई ऊर्जा के साथ आगे बढ़ेंगे कामगारों की आवाजाही उर्वरक सेक्टर में भी भारत रूस संबंध हर्ष कसौटी पर खरे उतरे मोदी 2023 तक आर्थिक सहयोग पर रणनीति बनाई मोदी से भारत रूस की दोस्ती ध्रुव तारे की तरह है आतंक के खिलाफ भारत रूस शानदार स्वागत के लिए आभार पुतिन से भारत रूस में लगातार बातचीत भारत रूस संबंध हर कसौटी पर खरे भारत दौरे पर पुतिन दोस्ती का नया अध्याय तकनीक के क्षेत्र में भी समझौता पुतिन से रूस तेल गैस का प्रमुख सप्लायर पुतिन से रूस में 7 अहम क्षेत्रों में समझौते रूस में स्वास्थ्य क्षेत्र में समझौता, भारत से मोदी पुतिन की दोस्ती, विशेष दुश्मनों को संदेश, मेडिकल एजुकेशन सेक्टर में भी समझौता। 2030 तक भारत रूस की दोस्ती ध्रुव तारे की तरह, मोदी से 25 साल पहले पुतिन ने पार्टनरशिप की नींव रखी, भारत रूस के बीच कई अहम समझौते हुए, मोदी से भारत रूस संबंध हर कसौटी पर खरे उतरे, मोदी आर्थिक सहयोग को नई ऊंचाइयों पर ले जाए। कृषि उर्वरक क्षेत्र में भी समझौता, मिलकर यूरिया उत्पादन के प्रयास, रूस नई ऊर्जा के साथ आगे बढ़ेंगे। ऊर्जा सुरक्षा हमारी मित्रता का स्तंभ, 2030 तक आर्थिक सहयोग पर रणनीति बनाई, मोदी से दोनों देश आर्थिक सहयोग बढ़ाएंगे, पुतिन से 25 साल पहले पुतिन ने पार्टनरशिप की नींव रखी, भारत रूस के बीच कई अहम मुद्दे, कई अहम समझौते हुए, मोदी से भारत रूस संबंध हर कसौटी पर खरा, भारत को बिना रोक टोक तेल देंगे, पुतिन से भारत दौरे पर पुतिन, दोस्ती का नया अध्याय। 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान, 25 साल पहले पुतिन ने पार्टनरशिप, भारत रूस के बीच कई अहम समझौते हुए, मोदी से भारत दौरे पर पुतिन, दोस्ती का नया अध्याय, भारत रूस संबंध हर कसौटी पर खरे उतरे, मोदी रूस में स्वास्थ्य क्षेत्र में समझौता, भारत और रूस में स्वास्थ्य क्षेत्र पर समझौता, मेडिकल एजुकेशन पर समझौता, शिपिंग जहाज बनाने को लेकर समझौता, अस्थायी लेबर एक्टिविटी पर भी समझौता, भारत रूस मित्रता ध्रुव तारे की तरह, भारत रूस संबंध हर कसौटी पर खरे उतरे, मोदी चुनौतियों के बीच मित्रता ध्रुव तारे की तरह है, आर्थिक सहयोग को नई ऊंचाई पर ले जाए, रूस भारत 25 साल पहले पुतिन ने पार्टनरशिप की नींव रखी, कृषि उर्वरक क्षेत्र में समझौता, मिलकर यूरिया उत्पादन के प्रयास, भारत रूस संबंध हर कसौटी पर खरे उतरे, मोदी रूस भारत नई ऊर्जा समझौता, ऊर्जा सुरक्षा हमारी मित्रता का संबंध, पुतिन से आतंकवाद मानवता के मूल्यों पर प्रहार, पीएम से 25 साल पहले पुतिन ने पार्टनरशिप की नींव रखी, दोनों देश आर्थिक सहयोग बढ़ाएंगे, पुतिन से 23वां भारत रूस सम्मेलन, पुराने रिश्ते नए, मॉस्को से आया मेरा दोस्त पुतिन, दोस्ती का नया अध्याय, भारत दौरे पर पुतिन, 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान, भारत रूस की दोस्ती ध्रुव तारे की तरह, 25 साल पहले पुतिन ने पार्टनरशिप की नींव रखी, तकनीक के क्षेत्र में भी समझौता, पुतिन से मोदी पुतिन की दोस्ती, विशेष दुश्मनों को संदेश, ऊर्जा क्षेत्र में भी सहयोग जारी रहेगा, भारत रूस संबंध हर कसौटी पर खरे उतरे, मोदी भारत रूस मित्रता ध्रुव तारे की तरह है, भारत रूस में 7 अहम क्षेत्रों में समझौते, भारत रूस की दोस्ती ध्रुव तारे की तरह है, 25 साल पहले द्विपक्षीय वार्ता, भारत रूस का साझा बयान, भारत रूस का साझा बयान, 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान, द्विपक्षीय वार्ता के बाद साझा बयान, भारत रूस का साझा बयान, भारत दौरे पर पुतिन, दोस्ती का नया अध्याय, द्विपक्षीय वार्ता के बाद साझा बयान। International law ABL positive morality. Is international law ABL positive morality? In order to know whether international law is a mere positive morality, it is necessary first to know that it is necessary first to know what is a rule of morality and then what is the differences between a rule of morality and a rule of law. As pointed out by Professor Oppenheim, a rule is a rule of morality if by common consent of the community it applies to conscience and to conscience only, whereas on the other hand a rule is a rule of law if, if by if by common consent of the community it will eventually be enforced by an eternal power. Thus, a rule of morality is a rule which applies to conscience only and cannot be enforced by external power. The rule of law, on the other hand, can be enforced by external power. There is now general agreement about the binding nature of international law, whereas a rule of morality is not binding. International morality or ethics has been defined as standards of right behavior that are based on personal judgments. Further, although attitudes about morality, when widely shared, influence the development of international law, there is no recognized legal obligation to international law. Frederick Pollock has rightly observed if international law were only a kind of morality, the farmers of state papers concerning foreign policy would show all their weight on moral arguments. But as a matter of fact, this is not what they do. They appeal not to the general feeling of moral rightness, but to precedents, to opinion of specialists according to Professor Shelley Hart. There are a number of different reasons for resisting the classification of rules of international law as morality, he points out. भारत रूस का साझा बयान, मोदी पुतिन की दोस्ती विशेष दुश्मनों को संदेश, डिफेंस डील की उम्मीद 500 एस 7 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान, भारत रूस का साझा बयान, मास्को से आया मेरा दोस्त, दोस्ती का नया अध्याय, भारत दौरे पर पुतिन, पीएम मोदी राष्ट्रपति पुतिन का साझा बयान, भारत रूस में स्वास्थ्य क्षेत्र में समझौता, डिफेंस डील की उम्मीद, SU-57 पर S-500 पर मोहर, 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान, भारत रूस में स्वास्थ्य क्षेत्र में समझौता, शिपिंग जहाज बनाने को लेकर समझौता, भारत दौरे पर पुतिन, दोस्ती का नया अध्याय, भारत रूस का साझा बयान, भारत रूस के बीच कई अहम समझौतों का ऐलान, भारत रूस के बीच कई अहम समझौतों का ऐलान, मोदी राष्ट्रपति पुतिन, भारत रूस में स्वास्थ्य क्षेत्र में समझौता, शिपिंग जहाज बनाने को लेकर समझौता, भारत रूस का साझा बयान, 23वां भारत रूस सम्मेलन. The first is that states often research each other for immoral conduct or praise themselves or others for living up to the standard of international morality. No doubt one of the virtues which a state may show or fail to show is that of abiding by international law, but that does not mean that law is morality. In fact, the appraisal of a state's conduct in terms of morality is recognizable, different from the formation of claims, demands, and the acknowledgement of rights and obligations under the rules of international law. Claims under international law are not couched in such terms, but of course. Though of course, claims under international law are not couched in such terms, though of course, as in municipal law, they may be joined with a moral appeal. What predominates in the arguments, often technical, which states address to each other or disputed matters of international law are references to precedents, treaties, and juristic writings. Often no mention is made of mutual right or wrong, good or bad. The rules of international law. The rules of international law, like those of municipal law, are often morally quite indifferent. A rule may exist between it is convenient or necessary to have some clear fixed rule about the subject with which it is concerned, but not because any moral importance is attached to the particular rules. It is clear that in the practice of state, certain rules are regularly respected even at the cost of certain sacrifices. Claims are formulated by reference to them. Breaches of the rules expose the offender to serious criticism and are held to justify claims for compensation or retaliation. These surely are all the elements required to support the statement there exist among states rules imposing obligations upon them. As pointed out earlier, a distinction is made between moral and legal principles, and while the former apply to concerns only, the latter create obligation. For example, the International Court of Justice in Southwest Africa cases second phase made it clear that the court can take account of moral principles only insofar as these are given in a sufficient expression in legal form. But even the word court cannot always ignore the role of morality, and the court has time and again accepted the relationship between morality and international law. For example, in the North Sea continental shelf cases, the morality and international law. For example, in the North Sea continental shelf cases, the court observed whatever the legal reasonings of a court of justice, its decisions must by definition be just and therefore in that sense equitable. Nevertheless, when mention is made of a court dispensing justice or declaring the law, what is meant is that the decision finds its objective justification in considerations lying not outside but within rules. And in this field, it is precisely the rule of law that calls for the application of equitable principles, whether international law is the vanishing point of jurisprudence. Holland has remarked that international law is the vanishing point of jurisprudence. In his view, rules of international law are followed by courtesy and hence they should not be kept in the category of law. According to him, rules of international law cannot be kept into the category of law because they lack sanction, which is an essential element of municipal law. Austin also subscribes to this law, just as we are Krishna Iyer, formerly member, Indian Law Commission, has also remarked it is a sad truism that international law is still the vanishing point of jurisprudence. This view is not correct. It is now generally agreed that Holland's view that international law is the vanishing point of Holland's view is based on the proposition that there are no sanctions behind international law, although it cannot be conceded that the sanctions behind international law are much weaker than their counterparts in the municipal law. Yet it cannot be successfully contended that there are no sanctions at all behind international law. For example, if there is a threat to international peace and security under Chapter 7 of the UN Charter, the Security Council can make necessary action to maintain or restore international peace and security. Besides this, the decisions of the International Court of Justice are final and binding upon the parties to a dispute. A number of other sanctions exist under different international organizations such as ILO, ICAO, WHO, UPU. As pointed out in ninth edition of Open Game International Law, an emerging system of sanctions for the enforcement of international law is discernible. There are also certain other indications of growing maturity and in international order. Further, there is similarly increasing acceptance that the rules of international law are the foundation upon which the rights of states rest, and no longer merely limitation upon the rights of states rest, and no longer merely limitations upon states' rights, which, in the absence of a rule of law, to the contrary, are unlimited. ICAO, WHO, CPU, etc. have similar sanction and have their own ways and means to enforce law and ensure its observance. Last but not the least, public opinion is the ultimate sanction behind international law and for that matter, any law. मेडिकल एजुकेशन पर भारत रूस के बीच समझौता, कामगारों की आवाजाही पर समझौता, उर्वरक सेक्टर में भी भारत और रूस में समझौता, शिपिंग जहाज बनाने में समझौता, शिपिंग ट्रांसपोर्ट को लेकर भारत रूस में समझौता, 25 साल पहले साझेदारी घेरे में रखी, 23वां भारत रूस शिखर सम्मेलन, कामगारों की आवाजाही पर दोनों देशों में समझौता, मोदी पुतिन की दोस्ती विशेष दुश्मनों को संदेश, आज इसने को और मजबूत किया, आर्थिक सहयोग को नई ऊंचाई पर ले जाएं, शर्म और दूरसंचार क्षेत्र में दोनों देशों में समझौते। Thus, it is wrong to say that there are no sanctions at all in international law. As remarked by RWM Daesh, the principal reasons why states obey international law appear to be fear and self-interest. Fear operates through the word reprisals, restoration, Pacific blockade, and naval military demonstration. It cannot, however, be denied that the greatest shortcoming of international law is the absence of effective machinery to carry out sanctions. It may be noted just because the simple truism which hold good for individuals do not hold for states, and the factual background to international law is so different from that of municipal law. There is neither a single necessity for sanctions desirable, though it may be that international law should be supported by them, nor a single prospect of their safe and efficacious use, that no simple deductions can be made from the necessity of organized sanctions to municipal law in its setting of physical and psychological facts to the conclusion that without them international law in its very different setting imposes no obligation, is not binding, and so not worth the title of law. Poland regards international law as the vanishing point of jurisprudence because in his view there is no judge or arbiter to decide international disputes, and that the rules of international law are followed by states by courtesy. This view is far from truth in view of the developed and changed character of international law today. It is incorrect to say that international legal system is without a court to decide international disputes. The establishment of the Permanent Court of International Justice under the League of Nations has rightly been reckoned as a landmark for the development of international law. International disputes through judicial decision, the greatest proof of its utility and importance is the fact that its successor, the International Court of Justice, established under the UN Charter, is based on the Statute of the Parliament Court of International Justice. It is true that the decisions of the International Court of Justice are not equivalent to the municipal courts. Nevertheless, the decisions of the International Court of Justice possess binding force and can be enforced under certain circumstances. They are binding upon the parties to dispute and only in respect of that disputes. The provision to this effect is contained in Article 59 of the Statute of the International Court of Justice. Besides this, Article 94 of the United Nations Charter provides that each member of the UN undertakes to comply with the decisions of the International Court of Justice in any case to which it is the party. Article 94 further provides that if any party to a case fails to perform the obligation incumbent upon it under judgment rendered by the court, the other party may have recourse to the Security Council, which may, if it deems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment. Thus, we see that the international legal system is not only provided with a judicial organ to resolve international disputes, but its decisions are binding and can be enforced under the conditions and circumstances as stated above. So far as the question of jurisdiction is concerned, Article 36(2) of the Statute of International Court of Justice provides that the state may confer compulsory jurisdiction upon the court in all legal disputes concerning or interpretation of a treaty, any question of international law, existence of any fact if, which if established would constitute a breach of an international obligation and the nature or extent of the reparation to be made for the breach of an international obligation. A number of states have conferred compulsory jurisdiction upon the court. Thus, the court exercises compulsory jurisdiction on a large number of international disputes. Moreover, leaving apart a few exceptions, decisions of the court have been respected and implemented. सभी मंचों पर सवाल सहयोग जारी रखेंगे पीएम से हिंदुस्तान के खिलाफ भारत रूस एकजुट आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से मॉस्को से आया मेरा दोस्त हर दौरे पर पुतिन दोस्ती का नया अध्याय आतंकवाद के खिलाफ वैश्विक एकता बड़ी ताकत चुनौतियों के बीच मित्रता ध्रुवतारे की तरह आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से कृषि उर्वरक क्षेत्र में भी समझौता आतंकवाद मानवता के मूल्यों पर प्रहार आतंकवाद के खिलाफ वैश्विक समझौता सभी मंचों पर सहयोग जरूरी रखेंगे पीएम से 23वां भारत रूस सम्मेलन पुराने रिश्ते नई उड़ान आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से भारत रूस में समझौता दोनों देश आर्थिक सहयोग बढ़ाएंगे भारत रूस मित्रता ध्रुवतारे की तरह पीएम से आतंकवाद के खिलाफ वैश्विक एकता बड़ी ताकत चुनौतियों के बीच मित्रता ध्रुवतारे की तरह कृषि उर्वरक क्षेत्र में भी समझौता पीएम से मोदी पुतिन की दोस्ती विशेष दुश्मनों को संदेश सभी मंचों पर आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से आतंकवाद के खिलाफ मिलकर समझौता 66 साल के लिए आभार पुतिन से आतंकवाद के खिलाफ वैश्विक एकता बड़ी ताकत आतंकवाद मानवता के मूल्यों पर प्रहार पीएम से दोनों देश आर्थिक सहयोग बढ़ाएंगे पुतिन से तकनीक के क्षेत्र में भी समझौता It is true that the decisions of the International Court of Justice are not equivalent to the municipal courts. Nevertheless, the decisions of the International Court of Justice possess binding force and can be enforced under certain circumstances. Thus, we see that the international legal system is not only provided with a judicial organ to resolve international disputes, but its decisions are binding and cannot be enforced under the conditions and circumstances as stated above. As noted above under Chapter 7 of the UN Charter, the Security Council possesses wide powers to declare sanctions against the states who are guilty of violation of the provisions of the UN Charter relating to international peace and security. Besides United Nations, there are sanctions in other intergovernmental organizations such as International Labour Organization (ILO), World Health Organization (WHO), International Telecommunication Union (ITU), International Civil Aviation Organization (ICAO), International Monetary Fund (IMF), World Trade Organization (WTO). Example, for example, in case of a dispute relating to the obstruction in International Civil Aviation Organization (ICAO), the decision of the Council of ICAO is binding. Similarly, International Labour Organization (ILO) has a special mechanism by which it functions to evaluate and promote compliance and standards. This mechanism consists of the following: through the ILO's regularly reporting structure, through special mechanisms established to protect freedom of association, commissions of inquiry, and the representatives under which procedure a committee is appointed by the government body, which then likewise reviews the committee report. It need not be overemphasized that unlike state or municipal law, public international law operates in a decentralized system. Its sanctions are therefore distinct and different from that of municipal law. Thus, international law is in fact a body of rules and principles which are considered to be binding by the members of international community in their intercourse with others. If a state violates rules of international law, it can be enforced by an external power. In innumerable treaties, states have not only accepted it to be binding but also confirmed the fact that it is a law between themselves. They also accept international law by asking their officers, courts, and nationals to act in accordance with organizations' obligations imposed by international law. The legal character of international law has also been recognized in the international law. The legal character of international law has also been recognized in the 1970 Declaration on the Principles of International Law concerning friendly relation and cooperation among states. The seventh principle of this declaration says it is the duty of every state to fulfill in good faith its obligations under the generally recognized principles and rules of international law. So is the case with the declaration on the enhancement of the effectiveness of the principle of refraining from the threat or use of force use of force in international relations adopted by the General Assembly of the UN on 18 November 1987. On the basis of our discussion, it may be concluded that international law is in fact law and it is wrong to say that it is the vanishing point of jurisprudence. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainer, professor, officer, official, listener, learner. I thank respected Dr. Jet directors, I thank adorable Minister Jet manager, I thank all honorable advocates, represented Mr. Advisor, I thank the most honorable President Mr. Ji. Good morning to all of you. Thank you. Nice to see all of you. Have a nice day, nice time. Thank you very much. भारत को फ्यूल सप्लाई जारी रहेगी, पुतिन से स्मॉल पोर्टेबल परमाणु तकनीक देंगे। पुतिन से तकनीक के क्षेत्र में मोदी पुतिन की दोस्ती, विशेष दुश्मनों को संदेश। ग्लोबल रीजनल मुद्दों पर हमारी बात हुई पुतिन से। हमने नई चुनौतियों पर भी बातचीत की। पुतिन ऊर्जा क्षेत्रों में भी सहयोग जारी रहेगा। हम आर्थिक सहयोग आगे बढ़ाएंगे। पुतिन से वैश्विक क्षेत्रीय मुद्दों पर भी हुई चर्चा। भारत रूस मित्रता ध्रुव तारे की तरह भारत को फ्यूल सप्लाई जारी रहेगी। पुतिन से 23वां भारत रूस सम्मेलन, पुराने रिश्ते नई उड़ान। थैंक यू, थैंक यू।